President Biden had already said that he wants to spend his remaining months in office working on bold reform to the United States Supreme Court. Today, he finally spelled out what that means. He called for 3 specific changes. 1, fix the damage done by the recent court decision that said presidents are free to commit crimes without fear of prosecution. He says that should be undone the only way you can undo something like that, which is with a constitutional amendment. Number 2, he said there should be term limits for Supreme Court justices. They shouldn't serve for life anymore. He said there should be 18-year terms. He said that would have the effect of stopping any single president from reshaping the bench for a generation. And third, he said we should institute a binding code of conduct, an ethics code, so justices would at least need to report things like the lavish vacations they have quietly been accepting from rich people who have an interest in the cases that are before the court. That today was President Biden's very specific 3-part pitch for trying to restore public trust in the Supreme Court. Now, at least one justice, Justice Elena Kagan, has already said yes to part of that in concept, saying there does need to be an enforceable code of ethics. Justices should no longer be allowed to just police themselves, since clearly that is not working. So there's that to start. Writing today at Slate.com, the civil rights attorney and legal scholar Cherylyn Eiffel underlined the urgency of this moment. She said, quote, in just the last 3 terms alone, this court has upended longstanding precedents, fundamentally changing the allocation of power between the branches of government, wiping away rights it formerly deemed fundamental, and upending the protections and guarantees upon which tens of millions of Americans had come to rely for decades. Joining us now is Sherrilyn Ifill. She's the Vernon E. Jordan Jr. Endowed Chair in Civil Rights at Howard University Law School, and one of my favorite people to talk to about anything, but especially the Supreme Court. Sherrilyn, it's really nice to see you. Thank you for being here.
Thank you, Rachel.
You have been an advocate for a long time that the court needs discipline, effectively, that the court needs reform, that it has behaved in such a way in recent years that rightfully call its legitimacy into question to the public in a way that's dangerous, given the important role of the court in our society and in our system of government. What do you assess as the sort of the weight, the heft, the potential to meet the moment of these reforms proposed today by President Biden?
Well, it's going to be a very steep climb. Obviously, this is not something that can be done by presidential fiat or by executive order. It would require Congress to pass legislation. And that means that obviously this will not happen with this Congress. But if the next Congress is to take it up, it would likely mean you would have to have a majority of Democrats in both the House and the Senate. And that's why talking about this election, it's important to not just talk about the president if you want Supreme Court reform. But it's also a heavy lift because, look, Rachel, it's difficult. It's difficult for me as a litigator to talk about these kinds of reforms and the need for them. But as a civil rights lawyer, as someone who believes in democracy, and as someone who understands the power of this court, not only to hold the line and the rule of law, but also to get us off the track of healthy democracy. The court has done it in the past. And I think we have to take very, very seriously what this court is doing, the track that it's on, and what it could potentially do to our country.
It is my sense that the effort around the Trump-Vance candidacy in the Republican Party is in part about trying to get them votes, but it is in a significant part about trying to get the election to be contested in some technical way so that it ends up in the courts for some reason or another. Because I believe Republicans think as long as it gets into the courts, it gets ultimately to the Supreme Court. And no matter what is before the Supreme Court, they would do whatever was necessary to put Donald Trump back in the White House. I say that as a non-lawyer and just an observer of the political processes here and what Republicans have been working on in the lead up to this election. Can I ask if you share those concerns?
If you had asked me this question a year ago, I might have hesitated. But after the Supreme Court's decision in the 14th Amendment Section 3 case, in which the court essentially read out of the 14th Amendment the provision that says insurrectionists cannot serve by coming up with this idea that Congress needs to pass some legislation to make that provision of the 14th Amendment effective, the court's decision in the charges brought by the Justice Department against many of the January 6 rioters And then, of course, finally, the Trump immunity case, the presidential immunity case, which is absolutely mystifying unless you believe what the dissenters, I think, the three women appointed by Democrats have been trying to tell us. And their dissents have grown ever more strident and strong as they have tried to warn us that this court essentially is behaving as though it is in the tank for Trump. It does not matter to me whether they are, in fact, in the tank for Trump. That is how they are behaving. And they are making leaps and bounds. This is the part that it's hard, I think, for non-lawyers to understand, is how the court is violating the rules of litigation, the way we bring cases before the court, who we say can bring cases before the court, how those decisions are made, what kinds of questions are raised by a piece of litigation. The court is making fast and loose with those rules that govern how people like me litigate in the court. And so they are so recklessly determined to get to the outcome that they want in these cases, not that just the Trump case, but the abortion case, the affirmative action case, that they are running roughshod over the rules that we play by. And that's what makes a legal system fair, is if we all have to abide by the same rules. And once you don't have the same rules of the game, you no longer have a legal system of integrity. And so I think at this point, we have to recognize what is in front of us. We may not want to, but we have to. And I'm gratified that President Biden, this has been a long road for him as well, at least has clearly put this issue before the American people. And Vice President Harris has endorsed it as well. And we have to grapple with our reticence and our discomfort and confront the fact that this also can be a threat to our democracy. It's not just Donald Trump. It is also a court that does not see itself bound by any rules and that appears to have an agenda.
Cherylyn Eiffel, Endowed Civil Rights Chair at Howard University Law School. Thank you for this. That is both hard to hear and it strikes me as profoundly true. Thank you so much. It's good to see you.
Thank you, Rachel.
We'll be right back.